Good morning to you. Today we will see the remaining rights of freedom of religion, which consists of Article 25, 26, 27, and 28, of which we have already seen Article 25. Now we are coming to Article 26. As I already told you, these all the rights 25, 26, 27, 28 put together we call religious rights or secular rights or freedom of religion. So 26 states subject to public order, morality, and health. Subject to public order, morality, and health. POM. P-O-M-H. Every religious denomination or any section thereof has 4 rights. What are the 4 rights? To establish and maintain institutions for religious and charitable purpose. For 2 purpose, one is religious purpose and the other is charitable purpose. Second is to manage its own affairs in the matter of religion. Second right. Third is, remember, to acquire and own movable and immovable property. Remember, movable and immovable property, acquiring and ownership. Remember, for individuals, this right has been deleted through 44th Amendment Act. Whereas for religious institutions, the acquisition of property is there, the ownership property is there. And fourthly, to administer such properties according to law. So very simple. These are all the 4 rights available under Article 26. To whom? To all denominations. Who? To all denominations. See, what do you mean by religious denomination? 3 conditions should be satisfied to identify a religious denomination. Number 1, it should be a collection of individuals who have a common faith. Common faith, very crucial. Secondly, this should have a common organization. Thirdly, it should have a distinctive name. These 3 qualifications are required for defining a denomination, religious denomination. Accordingly, Supreme Court has held Anand Margi and RK Mission are religious denominations under Hindu fold. Remember. So, what is denomination we have seen? What are all the requirement of a denomination we have seen? And what is the corollary we have seen? Second is, in another case, remember under Article 25, in another case, breaking coconuts and performing puja, chanting mantras and sutras in state functions are part of Indian tradition and religious practice. It has been recognized by the Supreme Court. State does not prohibit, secular state does not prohibit the practice of religion because there is no constitutional guarantee to the faith of atheists who worship barren reason that there is no God. Because remember, I have already told you when we discussed what are the qualifications of a secularism, it is neither pro-religious, nor anti-religious, nor irreligious. We are not irreligious. We appreciate the reality of unseen. So this is a Supreme Court decision. In state functions, breaking of coconut is not violation of Article 25. Number 1. Next point to be noted is Article, the 2 children norm. Secondly, the 2 children norm for Panchayat in Haryana. This has been upheld. This is not in violation of Article 25. It is also Supreme Court has upheld. And now we come to Article 27. Article 27 provides that no person shall be compelled to pay any tax, the proceeds of which are specifically appropriated for the promotion of any particular religion. One particular religion, for promotion of one particular religion, it should not be appropriated. If the state aid is extended to all religious institutions along with the secular one without any discrimination, the prohibition does not apply. Remember, Hajj subsidy, similarly, Mansarovar. Every religions are treated as equal. There is no discrimination. It has also been held that the state can, in exercise of its sovereign power, acquire places of worship in the interest of public order. Very important decision of the Supreme Court. It was held by the Supreme Court that it does not violate Article 25 and 26. What does not violate? The sovereign power to acquire the places of worship in the interest of the public. What is protected is a religious practice, which is an essential and integral part of religion. A practice may be religious, but not essential part of religion. For example, while offer of prayer or namaz is an essential part of religious practice, the place where such practice is to be done is not an essential part. You cannot insist that the namaz should be read only in particular place. But reading namaz is an essential part, but not the place where it should be recited. This was declared in Ismail Faruqi case in 1994. 1994, very important. Then comes Article 28. Then we are switching over to Article 28. It relates to prohibition of religious instructions in state-aided institutions. State-aided institution. Imparting religious instructions in state-aided institution. Remember, you divide all the educational institutions in 4 categories. What are all the 4 categories? Number 1, the educational institutions established and wholly maintained out of state funds. Remember, I have told you 4 kinds. First kind is any education institution which is established and maintained wholly out of state funds. Number 1. Number 2 is the education institution established under the trust but administered by the state. Okay? It is established under the trust but administered by the state. This is the second category. Number 2, educational institutions recognized by the state. Number 3. Number 4, educational institutions which are receiving aid out of state funds. So these are all the 4 categories. Number 1, wholly maintained out of state funds. Secondly, administered by the state but established by the trust. Third is which is recognized. Fourth is which is receiving aid from the state. So these are all the 4 categories. Now come to the education, very easy to remember. Now come to the imparting religious instructions. Number 1, first category, that is which is maintained wholly out of state funds. Totally forbidden. No religious instruction can be imparted in any educational institutions which are wholly maintained out of state funds. Okay? Then secondly, any education institution which is administered by the state but set up by the trust, set up by the established by the under the trust. Here, remember, religious instruction can be imparted. There is no prohibition. Why? It's obvious reason. Suppose you are teaching Sanskrit. Can you teach Sanskrit without mentioning about the Hinduism? Absolutely not possible. So when it is established under the trust, religious instruction can be imparted. Number 3. Number 2. Number 3. Educational institution recognized in the state and education institution which are receiving aid from the state. These 2 categories, religious instruction can be given only on the consent of the person, consent of the child. If the child is a minor, the guardian should agree. So, very simple. In all the 4 cases, first is not possible, second is possible, third and fourth possible with the consent of the candidate. If the consent is minor, then the guardian should agree. Very simple, fine. Next we are coming to article totally, that is educational and cultural right. Educational and cultural right. That is 28 is over, 29 and 30 cultural and educational rights. Right to freedom is over now, 25, 26, 27, 28. Now we are coming to 29 and 30, which is cultural and educational right. These rights are called minority rights. Remember, these rights are called minority rights. The term minority has not been defined in the Constitution. This has been given to the Minority Commission, but they have not decided so far. It is on the way. Secondly, the point which you should remember is, when we mention minority, the article says a section of society. Remember, it is not the normal temptation of saying this community is minority, this community is majority. No. The minority or majority is to be decided with reference to the population in the demographic population in the place. Suppose in Maharashtra, Keralites are minority. In Tamil Nadu, North Indian, Gujaratis are minority. So that minority, majority should be in that particular state. That has to be taken into account. That point you should remember. Secondly, the article 29. Let us come to article 29. The first proviso guarantees the every section of citizen. I have already told you, every section of citizen, not minority, majority, religious, etc. Every section of citizens have been guaranteed to conserve their distinct language, script or culture. LSC, language, script or culture. This is first clause. Second clause is, it provides that no citizen shall be denied admission in any education institution maintained by the state or receiving aid from the out of the state funds on the ground of religion, race, caste or language. So one is non-denial of admission in education institution. Second is the general right to every section of citizens to conserve their distinct language, script or culture. Remember, the first proviso protects the rights of the group, while the second proviso guarantees the rights of the citizen. Remember, in this, the first proviso protects the rights of the group. Okay. But the second proviso guarantees the right of the citizens irrespective of community. The protection is, remember, for both linguistic and religious minorities. Remember, in fact, this is not necessarily restricted to a minority alone, because the term used is section of citizens, which includes minority and majority. Remember, this is very important. Secondly, the Supreme Court has held that the right to conserve language, we told you, conserve language includes right to agitate for the protection of language of a section of society. Remember, conserve language includes a right to agitate for the promotion of the language. Precisely for this reason, the political speeches on language does not attract the quote corrupt practices defined under RPA 51, Representation of People Act 1951. Those provisions do not attract the political speech made with reference to language, because the conservation of language is included in the right given in Article 29. Remember, very important. Linguistic minority, remember, is the responsibility of the state government, and religious minority is the responsibility of the central government. So accordingly, 6 minority communities have been recognized. What are they? Muslims, Sikhs, Christians, Jains, Buddhists and Zoroastrians. These 6 communities, minority communities, have been existing in our country. The linguistic minority is one which has a separate spoken language. Remember, spoken language, there is no need for any distinct script. Incidentally, remember, a community less than 50% population is considered a religious community. Less than 50% is a religious community. In fact, recently you might have heard a plea was made in Supreme Court recently seeking minority status for Hindus in 7 states and 1 union territory where the Hindus are in minority. Those states, as you know, Lakshadweep 2.5% Hindus, Mizoram 2.7%, and Nagaland 8.75%, Meghalaya 7.53%, J&K 28.4%, Arunachal Pradesh 29%, Manipur 31.3%, Punjab 38.4%. In spite of Hindus being in minority, they do not enjoy the minority status. Accordingly, Supreme Court has asked the National Commission on Minorities to define the term minority and also their comments on the plea. The definition of minority is still to come from National Commission on Minority. So this is Article 29. Now we come to Article 30. Article 30 has 3 provisions. All minorities, whether based on religion or language, have the right to establish and administer educational institutions of their choice. Remember, linguistic and religious minorities have the right to establish and administer educational institutions of their choice. Number 1. The state shall not discriminate in granting aid to any education institution on the ground that this institution is under the management of a minority based on a particular religion or particular language. These are all the 2 important provisions available under Article 30. In addition, lastly, very simple, in making compulsory acquisition or takeover of property of any education institutions of such minority, the state shall ensure that the amount fixed for is adequate. Adequate. That is the whatever compensation, nationalization or takeover, then the compensation should be reasonable, adequate. Article 30 includes the right of minority to impart education to the children in their own language. Remember, mother tongue, vernacular. In their mother tongue, elementary education should be imparted. There are 3 kinds of minority educational institutions. Minority educational institutions are of 3 types. One is education institution which seeks recognition and aid from the state. Secondly, which seek only recognition from the state. Thirdly, which seek neither recognition nor aid from the state. Remember, we are divided into 3 categories. One is which is seeking recognition and aid, and another is which seeks only recognition and not aid, and the third is neither recognition nor aid from the state. They don't expect anything. So remember, in this, the first and second type of institutions are subjected to regulation by the state with reference to teacher salary, teaching staff, with regard to syllabus, with regard to academic standards, employment of teaching staff, etc. The third type of institutions are free to administer their own affairs. However, they are subject to general law like income tax, tax law, as well as labor law, industrial law, contract law, etc. Other general laws will, provisions of the law will be governing the third category of the educational, minority education institution. Thank you. We will come to the very important thing on Article 32. 30 is over. As far as 31 is concerned, we have already seen 31A, 31B, 31C. Article 31A, I have already explained. That is I mean, any law can be made for what is known as abolition of zamindari system and agrarian reforms. If any law is made, that law cannot be questioned in any court of law, even if it violates the Article 14 and 19 and 14, 19 and 31, which is deleted. Similarly, what is known as Article 31B and Schedule 9, if any land reforms are included in Schedule 9, it cannot be challenged even if it violates Article 14, 19 and 31. Then Article 31C, 25th Amendment Act added and to implement the Article 39B and C of the Directive Principles of State Policy, and if any law is made to implement Directive Principle Article 39B and C, that law cannot be questioned even if it violates Article 14, 19 and 31, which has been since been deleted. So this 31 is already, we have, I think I remember to dictated 3 times in the earlier cases, and now in the next class we are coming to the most important article 32. Thank you very much.